Ms. Kilroy, I think you're on screen now, and we both are. You have submissions to make on behalf of Category H and then 2 individual call participants. My understanding is that you would like to make and finish the Category H submission and then have a short break.
That's right. Thank you very much, sir.
And do please begin.
So the Category H core participants include 25 women who were deceived by undercover police officers into intimate sexual relationships over a 50-year period between 1968 and 2010, and a child of one of those relationships. In Tranche 1, that is the period between 1968 and 1982, the evidence strongly suggests that at least 11 women were deceived into sexual relationships by SDS undercover officers or UCOs, and probably more. 8 of those women were deceived into sex by 2 UCOs, Richard Clark and Vincent Harvey. It's already clear that once the practice of UCOs entering into sexual relationships to gather intelligence on public disorder began, it did not stop. The practice spread and solidified, with UCOs adopting common tactics for entering into, maintaining, and extracting themselves from relationships. Relationships got longer and became more intense. Some UCOs even fathered children. The MPS, the Metropolitan Police Service, now accept that the use of sexual relationships by UCOs was wrong, abusive, and should not have occurred. But the evidence shows that there was widespread knowledge within the SDS of the risk of sexual relationships and that they were occurring. The lack of any effective measures, together with the persistence of the practice for almost 50 years, demonstrates that the use of sexual relationships to gather intelligence was at least tolerated. Sir, the fact that police invasions of the most fundamental right a person possesses, their bodily autonomy, occurred so extensively and for so long uncorrected, also exposes deep flaws in the application and implementation of the laws governing police conduct. Neither the common law, nor the UK's international obligations, nor the Human Rights Act, the HRA, nor the introduction of the Regulation of Investigatory Powers Act 2000, RIPA, prevented the Category H CPs from being abused by MPS officers. The long-term MPS tolerance of this deeply abusive practice, together with the fact that the legal framework did not prevent it, raises, in my submission, 2 important systemic issues for this inquiry. The first question is, why did no one in the MPS take any steps for almost 50 years to stop a practice which so many knew about and which the MPS now accepts is abusive and wrong? And the second question is, why didn't the law protect the Category H CPs? At the close of Tranche 1, having considered all the evidence and the applicable law, the Category H CP's position on these 2 critical questions is as follows. The reason why no one took any steps to stop UCOs from using sexual relationships with women was because the MPS was a deeply misogynist organization. That is clear both from the evidence of officers in this inquiry and from a report commissioned by the Metropolitan Police Service Commissioner, Sir David McNee, towards the end of the Tranche 1 period by the Policy Studies Institute entitled Police in Action. That 1983 PSI report, which was sent to the then Home Secretary Leon Britton, as well as to the MPS Commissioner himself, concluded that the MPS was dominated by what the PSI report called a cult of masculinity. The report shows that police officers in the MPS viewed female members of the public with contempt. They saw them as sexual objects to be joked about and derided. They boasted and fantasized about having sex, sometimes violent sex, with women, including vulnerable women, underage girls, and victims of crime. The evidence in this inquiry shows that the SDS officers deeply disrespected female members of groups, engaged in gross and offensive banter about them, and paid no regard to the impact on them or their lives of undercover officers' conduct. Sexual relationships were seen as carrying risks to a UCO's private and family life, but were otherwise regarded with jocularity and hilarity. They were considered as an inevitable consequence of UCO operations, which could be tolerated so long as they did not compromise the security of the SDS. As for the law, it's the Category HCP's position that it was not itself deficient. The reason it did not protect women was because the MPS did not consider it necessary to follow it. Had the applicable law been followed, it would have protected female members of the public from the abuses inflicted upon them, because none of the UCOs would ever have been sent on long-term, deep undercover deployments, which carried an inherent risk of sexual relationships. The SDS's long-term deployments necessarily involved torts, such as trespass to land and breach of confidence, and were deeply intrusive of private lives. But there was no imminent risk of serious crime or any other pressing necessity. That meant the deployments could not be justified. They were unlawful, both at common law and under human rights law at all material times, including in the Tranche 1 era. The problem was therefore not the law itself. The problem was that the MPS, including its most senior officers and commissioners, did not consider it necessary or desirable to comply with it. Contemporaneous materials, including biographies authored by MPS commissioners and the police in action report I've just referred to, together with the evidence in this inquiry, make clear that this attitude to the law was pervasive throughout the MPS at the time. Common law rules were treated as an impediment to policing, which it was only necessary to comply with to avoid civil actions for trespass or to ensure that criminal prosecutions did not fail. Human rights law was not considered at all. Since SDS work was treated as top secret, the MPS never expected to face civil actions or to give evidence in a criminal court. In those circumstances, they did not even think about whether what they were doing was lawful. In other words, the abuse of the Category H CPs in the T1 period and beyond is deeply rooted in two pervasive features of police culture: contempt for women and disregard for the law. The Category H CPs submit that these problems are so endemic and so dangerous to public safety and the public interest that root and branch reform of the police will be needed to eradicate it. Changes to the legal framework alone will not be sufficient to protect the public. Sir, the closing submissions of the three separate police participants in this inquiry, that is first the MPS Commissioner Mark Rowley, second the National Police Chiefs Council headed by Chief Constable Martin Hewitt, representing the interests of all Chief Constables, and thirdly, the designated lawyers' submissions on behalf of over 100 SDS officers confirm precisely that disregard for the law. All these state participants have asked this inquiry not to address the lawfulness of the actions of the SDS. They say this question of lawfulness can and should only be considered if and when a civil action is brought against them by a member of the public. They say this is the effect of Section 2 of the Inquiries Act, which prohibits the inquiry from ruling on any person's civil or criminal liability. The police's arguments about Section 2 of the Inquiries Act are wrong for the reasons set out in Counsel to the Inquiry's submissions on that section and on the law at paragraphs 2 to 21 and 78 to 80. As he explains, by reference to the approach taken to other inquiries and inquests, an assessment of legality is not a ruling on individual liability. Even where conduct is unlawful, this may not lead to a finding of liability. Legality and liability are two distinct concepts. An assessment of lawfulness will often be required in order to discharge an inquiry's functions. That, in my submission, is certainly true of this inquiry. it not only can, but must assess the lawfulness of the SDS's operations in the Tranche 1 period. It must do so because otherwise it cannot discharge its terms of reference. It cannot properly assess whether the SDS or the NPOIU's operations were justified, whether the legal and regulatory framework was adequate, what the impact of the public was, what the impact on the public was, including the impact on their rights, or what recommendations for change would be required, unless it reaches a view on whether those operations reached the basic minimum standard of lawfulness, and if not, why not? So the police's arguments to the contrary do not make sense. Littered throughout their submissions is the argument that, save for the use of sexual relationships, the operations were justified according to what they call the standards of the day. But the standards of the day include the legal standards. The inquiry cannot assess the police's submission unless it has determined what those legal standards were and whether they were complied with. But the significance of the police submissions, as I've already indicated, is far greater than just that they are wrong in law. An assessment of legality is what the MPS and the Home Office should have done in advance of any UCO from the SDS setting foot in anyone's premises, invading anyone's private life, and taking anyone's confidential information. It is the first duty of any public authority in a society governed by the rule of law to assess in advance of their actions whether the way in which they propose to use their powers is lawful, and to refrain from that action if the assessment is that the proposed use would be unlawful. That is especially so when the powers they intend to use are coercive and covert. There is no evidence that the MPS ever discharged this basic duty of every public authority. And having failed the public so profoundly, they now suggest this exercise should never be done, even by the public inquiry set up by the Home Secretary to examine what has gone so badly wrong. That is an untenable stance. It is also deeply concerning. Compliance with the rule of law should be deeply embedded in the police psyche. All the laws of the land should be what the PSI report calls working rules, and every effort ought to be made to ensure compliance with them, whether claims come to court or not. This is so far from the reality of police conduct and culture that the MPS Commissioner, the NPCC, together with the other 42 Chief Constables, don't even want to know what the law permits in terms of undercover policing, let alone commit to comply with it. I want to make a few other short points about the police's late submissions on the law before I come to the remainder of my closing. 10 months ago, the Category H CPs addressed the contemporary legal framework for police operations in Tranche 1. I want to make clear at the outset that there was nothing remotely novel or controversial about the law which we set out there. The common law principles and their application to the police have been clear for centuries. They were clear even before Entick and Carrington over 250 years ago. Those English common law authorities have always provided muscular protection to people's homes and private possessions, their confidential papers and views, especially from the police. That powerful protection for the home is how the common law ensures privacy and respect for family. The mechanism is different to Article 8 of the European Convention on Human Rights, but the protection is equivalent. Sir, this is all so well established that the words of Chief Justice Sir Edward Coke in 1644 in Sir Main's case, which was a case concerning sheriffs seeking to execute a civil writ inside a person's home, have even entered the vernacular. His words, with some modification through the ages, have become, "An Englishman's home is his castle." That ringing phrase is the foundation of modern concepts of privacy and protection against an overweening state. That is why the Category H CPs have stated that all sources of law speak with one voice on the following three principles. First, no general authorization may be given to the police or the security service to search individuals or property for evidence of wrongdoing. Second, police powers to trespass on land, property, and the person, and to interfere with private and personal lives will only be lawful where necessary and proportionate to meet a pressing social need, such as prevention or investigation of serious crime or an imminent breach of the peace. And thirdly, the use of covert powers by the police and the security service is a danger to democracy and is therefore subject to a particularly strict necessity test. Sir, on those principles, there isn't even a sliver of blue water between the common law and Article 8 of the European Convention. Indeed, if anything, the protection afforded by Article 8 is less, because a wider range of justifications can, in theory, be relied on to justify an interference with the home. On 9th of May last year, sir, you invited the police participants to respond to those submissions on the law. For almost 10 months, there has been stony silence. But on the 10th of February 2023, as part of their written closings, the 3 police legal teams and their 3 separately instructed King's Counsels have produced what is clearly a concerted position on the law. First, they say the Category H submissions on the law are novel and controversial, but that is obviously wrong for the reasons I've explained. These solid precedents in English law apply to police as well as the public. The principles do not become attenuated just because the policemen take their uniforms off and grow beards. They're not more relaxed for those who are spying on protesters than those investigating serious violent crimes. It is those seeking to commit trespass or break confidences who must justify it. Unless the MPS can point to special statutory powers permitting them to break the law in public order cases or undercover cases, which they can't, they are, quite simply, bang to rights. The police at the highest levels knew they were trespassing when they tricked their way into people's homes. MPS Police Commissioner Sir David McNee said as much in his 1983 biography, McNee's Law, at page 180 to 181. He complained that his officers had not been given the powers they needed to investigate crime and that they had been expected to rely on the ignorance of the population of their civil rights to do so. As he put it, many police officers have learned to use methods bordering on trickery or stealth in their investigations. They have frequently risked civil actions when doing so. But until the last decade, the number of civil actions brought against police officers was extremely small. I consider it quite wrong that police officers should be expected by stealth or by force, and at the risk of an action for trespass, to exercise necessary powers in the investigation of crime. He went on to describe how the increase in civil actions meant that, quote, "It is now increasingly clear that the days when investigating officers could expect to bluff their way into obtaining consent to take body samples or enter premises were numbered." It is not correct, therefore, for Mr. Sanders to say, as he did yesterday, that trespass did not occur to anyone before the Category H CPs raised it. It occurred to the police commissioners at the time. Second, the police say that they would run a number of defences to any claim of trespass. They say that police officers who could never obtain a warrant from a court to enter property can evade all this ancient protection that I've described this afternoon, by simply tricking their way into people's homes. Sir, this is indeed a novel and controversial argument, but the novelty and controversy is all on the police side. It is clear beyond argument that on the current state of the law, those invited onto property for one purpose may not use that license for another. That is House of Lords authority, Hillen and ICI. The sole case of Byrne, relied upon by all 3 police legal teams, is a first instance authority doubted by many who have considered it since. And even if it were a certain precedent, it would not avail the police. The license given by a cinema or a shop to the general public is broad and general and encompasses a wide range of purposes, or no particular purpose at all. A private person's invitation into their home, by contrast, is almost always targeted to known and identified individuals and contains an explicit or implicit purpose. Any deviation is a trespass. Sir, the police also suggest they would invite the courts to develop new defences on public policy grounds. They suggest that the courts, who have for hundreds of years refused to develop such defences for those investigating crimes such as murder and terrorism, would be prepared to develop them for police officers trying to discover how many people would attend a political protest. Again, this is hopeless. If the police want you, sir, to recommend the law should change, to permit them to trick their way into private homes when the courts would never grant them a warrant, now is the time to say so. That is what this inquiry is for. But the current law of the 20th and early 21st century is crystal clear. The SDS's operations prima facie involved routine, unjustifiable trespasses in the Tranche 1 era, and in my submission, you should say so. The third argument mounted by the police is that the SDS's operations were unjustified by modern standards, but justified by standards of the day. This argument is squarely based on the erroneous submission that the law in the Tranche 1 era did not protect people's homes and privacy from the police prior to the enactment of the Human Rights Act and RIPA. This surprising submission is completely wrong, as I've already explained. There will be many who will be interested in the police's view that the only thing standing between the British public and an East Germany-style police state is the Human Rights Act. But the basis for this view is false. The common law is more than equivalent to the task, as long as the police comply with it. Fourth, the police suggest that with the advent of RIPA and the Human Rights Act, the severe intrusions of the SDS Tranche 1 era would not have occurred. The Home Office in their closing submissions this morning have made a similar point, but these arguments are wrong. The excesses of Mark Kennedy and his fellow and undercover officers in the NPOIU all post-dated RIPA for some 10 years. They led the IPT, the Investigatory Powers Tribunal, in the Kate Wilson case to conclude that the MPS and the NPCC had violated almost every right in the European Convention on Human Rights when they spied on Kate Wilson. The problem is not the content of the law, although of course there can always be improvements. The primary problem is that the MPS do not comply with the laws that exist, unless forced to do so by constant supervision and the threat of legal proceedings. So I have produced a full written closing which performs the following key tasks. It addresses first the final state of the evidence about the SDS's activities in this period and the knowledge and responsibility of senior officers, ministers, and government officials for those activities. It explores how and why the SDS's serious breaches of key legal principles were allowed to occur. It sets out the conclusions, thirdly, that the Category H CPs draw on the law and evidence. The written closing also examines the wider policing context, and in particular, the role of police culture in the SDS's activities. I do not intend to address you orally on everything in this written closing. I intend instead to focus on three key areas of submission. First, the police culture and policing context, focusing especially on misogyny. Second, evidence about the SDS's activities and in particular, knowledge of sexual relationships. And finally, broad conclusions to be drawn. Turning first to police culture and the policing context. The Tranche 1 era was an especially febrile period for English policing as a whole. It's no exaggeration to say there was a crisis of confidence in policing in the 1970s. The abuses and excesses of the SDS did not take place in a vacuum. Policing in this period, more generally, was characterized by deep-rooted corruption, serious miscarriages of justice resulting from police wrongdoing, and civil disturbances. Some of this became public knowledge in the 1970s, prompting widespread public concern. There were, for example, major corruption scandals relating to the actions of the MPS's CID drug squad and obscene publication squad. The public was shocked to discover that so many police officers were taking bribes and working in concert with career criminals, and that there was a systematic, institutionalized and widespread network of corruption as the so-called firm within a firm. Another example, which led ultimately to the introduction of the Police and Criminal Evidence Act 1984, was the Maxwell Confate case, in which 3 teenage boys, including one with serious mental disabilities, were wrongly convicted for murder after false confessions. After their convictions were quashed in 1975, an official inquiry, the Fisher Inquiry, found that their rights had been violated by the police in a variety of ways, and evidence later emerged exonerating them completely. As I've said, reforms followed some of these scandals, and one of them was the Police and Criminal Evidence Act, known as PACE. There was other serious police wrongdoing in the Tranche 1 era that emerged somewhat later, such as the wrongful convictions of the Guildford 4 and the Birmingham 6. It's in this context, sir, that the misconduct of the SDS occurred. And it's my submission that many of the problems which emerged into the public domain decades ago, including the long series of miscarriages of justice, had a similar cause to the misconduct of the SDS, namely the police's long-standing cultural tendency to view the common law, legal parameters, and legal rules as impediments to their functions. As we will see, the Home Secretary at the time recognized this problem when he introduced PACE to Parliament in 1983, but unfortunately, he did not recognize its implications for the SDS. Turning now to police culture. As already indicated, it is the Category H's CP's case that the cause of the abuses they have suffered lie firmly in police culture, and in particular in misogyny and disrespect for the law. This is made clear by the PSI report I've already mentioned. That report was funded by the MPS and the City Parochial Foundation and requested by Sir David McNee. The PSI researchers were granted access to police officers at all levels in the organisation and allowed to observe all kinds of police work over 2 years between 1980 and 1982. I'm going to address 3 topics addressed by the PSI report today: compliance with legal rules and standards, attitudes to women, and wrongdoing by fellow officers. Legal rules and standards. The PSI report explains that not all rules which originate from the law are treated equally by the police. Rules can be divided into 3 types. Working rules. These rules are internalized by police officers to become guiding principles of their conduct. They are guiding principles because the police believe it is wrong to break those rules. Secondly, inhibitory rules. Those are not internalized, but they do tend to discourage police officers from behaving in certain ways in case they should be caught. And the third type is presentational rules, which exist to give an acceptable appearance to the way that police work is carried out. These conclusions were accepted by the Home Secretary Leon Brittan when introducing PACE to Parliament in November 1983. He stated, "Honourable members will no doubt have seen recent references in the press to a draft report on the Metropolitan Police by the Policy Studies Institute. That report, which is to be published very soon, makes the point that rules and legal constraints are not by themselves sufficient to ensure that powers are used properly. I fully accept that merely having a proper legal framework is not the whole answer. However, that is not a reason for not having such a framework." Unfortunately, as we've already seen from Sir David McNee's biography, the principles of common law intended to protect citizens against intrusions into their home and private lives fell into the category of inhibitory rules rather than working rules. These sentiments go a long way to explaining why no one in the MPS seems to have given a second thought to the legality of the SDS's practices. The principal concern of the MPS's most senior officers was that they should not get caught, and they did not expect SDS officers to be caught because of the secrecy of the work. So turning now to attitudes to women. The PSI report describes police culture in the relevant period in terms which are strikingly similar to the conclusions of the Independent Office for Police Conduct's Operation Houghton report about police officers in Charing Cross Station 40 years later in February 2022. The report also corroborates the evidence of HN 304 Graham Coates in this inquiry. Key findings from the report are as follows. The dominant values of the force are still in many ways those of an all-male institution, such as a rugby club or boys' school. This shows itself in the emphasis placed on masculine solidarity and on backing up each other men in the group, especially when they are in the wrong. The stress on drinking as a test of manliness and a basis for good fellowship, the importance given to physical courage, and the glamour attached to violence. This set of attitudes amounts to a cult of masculinity, which has a strong influence on policemen's behavior towards women, towards victims of sexual offenses, and towards sexual offenders. In groups of policemen, bawdy talk about sex and women is expected. Bawdy talk is described by the PSI report as a kind of game among groups of men in which they play in their imagination the role of a man triumphing over a woman. For example, an older PC said that in the old days, women police constables, when they first arrived at a police station, were always stamped on the bare bum with the station rubber stamp. This fantasy neatly symbolizes three chief impulses: the treatment of a woman as a thing, like a form to be filled in or rubber stamped, the humiliation of a woman, and sexual assault on her. The report also describes how police officers tell stories about sex. At one police station, the main subject of jokes for a considerable time was a story about two young police constables who were supposed to have had it for free with a prostitute while working a night shift in a panda car. The report also records that some constables take every opportunity to give detailed accounts of reported rape cases. The men involved in this kind of conversation sometimes imply not only that the women probably enjoyed the experience, but also that they would have liked to have committed the offense themselves. For example, a CID officer went to interview two teenage girls, the younger one aged 14, who alleged that they had been sexually assaulted in the flat where they lived. He came back saying that the girls had played the man along and that he found the two girls very tasty himself. In another example given by the report, three experienced constables engaged while on duty in a great deal of conversation about sex in very gross language in which the men were always conquerors and the women slags and whores. There was extensive boasting about drink, and this talk about sex, women, and drink was interspersed with descriptions of violent incidents that the PCs had witnessed, heard about, or taken part in. The report goes on to say that in the attitudes and talk of the men, ideas about the limitations of women specifically as police officers merge imperceptibly into general views about the inferiority of women, which again merge into sexual boasting and horseplay. Something of this mixture the report describes as being caught in a single remark by an older constable who said that, quote, "A young girl will be no good in restraining a violent man as long as she has a hole in her ass." The report says that talk about women on this level is pervasive among groups of men in the Met. Much of it is much more lurid and extreme than the small example which the report quotes. These findings of the PSI report are echoed elsewhere, and we've set out references in the written closing. Nor were these attitudes confined to the lower ranks. Thus, in several places in his biography in the office of constable, Sir Robert Marks makes sexualized and discriminatory remarks about women police officers and displays nonchalance about police officers having sex with women members of the public while on duty. And I've given page numbers in the written closing. Sir publicly denigrating and sexualizing women police officers for holes or splits in their arses seems to have been commonplace in the police for decades. It is also recorded by an article chronicling women police officers' experiences in the 1990s. One officer says, "We were called split arses." Equally long-lasting was the practice of stamping parts of women police officers' bodies with a station stamp. In a recent BBC News report, one of the victims of police officer and serial rapist David Carrick reports this happening as late as 2004. The PSI report concludes that these attitudes had a strong influence on policemen's behaviour towards women, towards victims of sexual offences, and towards sexual offenders. The PSI report strongly corroborates the evidence of HN 304 Graham Coates about the prevalence of gross sexual banter and undermines the evidence of those who deny that it took place in the SDS. As Graham Coates told the UCPI in his oral evidence, the, quote, nuts and bolts of the humour, so-called, were the same, and it made precious little difference whether one was a mainstream CID or uniform officer or a special branch officer. He gave an example of this kind of banter, which had plainly stuck in his mind as particularly lurid. He describes an officer saying of another officer's sexual conduct with a female member of the public, quote, "He'll have made her bite the blankets again last night." These attitudes explain, in my submission, why many officers felt no compunction in entering into sexual relationships with women and did not feel the need to report it to senior officers. As Vince Harvey explained, it was not of much importance. They also help explain why managers did not even acknowledge the adverse effect on women of relationships or take any meaningful steps to avert the risk of them, which they acknowledged arose. Moving on to wrongdoing by fellow officers. So a part of the cult of masculinity described in the PSI report is backing up others in the group. The report states, the solidarity among police officers generally, and particularly among small groups who work together, is extremely strong. The researchers were told many times that an officer who had done something wrong would always, or almost always, be backed up by other officers, even if they didn't like him. By way of example of this code, a uniformed sergeant in charge of a crime squad was asked whether he would shop one of his mates who had committed a serious assault on a prisoner. He said, "No, I never would. If one of the boys working for me got himself into trouble, I would get all of us together and I would literally script him out of it. I would write all the parts out, and if we followed them closely, we couldn't be defeated. And believe me, I would do it." When asked if it was wrong for police officers to get away with assaulting prisoners, especially as this would involve a conspiracy to cover up the evidence, he said, "Oh yes, but when it was all over, I wouldn't want anything to do with him." The thinking was that internal justice administered informally was far preferable to justice through the machinery of the complaints and disciplinary system of the force, partly because the penalties imposed were seen to be too severe, and partly because discipline was seen as something imposed from the outside, which threatened the group as a whole. The report records that the officers who investigated complaints accepted that police in the lower ranks almost always back each other up and normally tell lies. This powerful code, which enjoins officers to back each other up in the face of external examination, has been emphasized in multiple studies of the police. It is a protective armor shielding the force as a whole from public knowledge of infractions. The them and us outlook is characteristic of police culture. So I want to turn now to evidence about the SDS's activities. As set out in the written closing, the evidence shows that in the Tranche 1 era, The SDS closely monitored, recorded, and influenced the lawful exercise of fundamental democratic rights, including freedom of expression and political thought, freedom of assembly and political association. In doing so, undercover officers entered private homes, infiltrated private and family lives, and invaded the personal and private dealings of members of the public. They passed all the information they gathered out, including highly confidential information about people's private lives, medical information, and banking details. No one, either in the SDS, the MPS, or the Home Office, considered it necessary to respect the common law and human rights of individuals, and they did not consider the impact on those rights of SDS activities. Instead, the Home Office, MPS, and SDS prioritized the secrecy and security of SDS operations and the interests of police officers over all other concerns. There was little or no guidance or training. The SDS's UCOs were not subject to any meaningful internal or external limits and controls, and there was no accountability in any forum for the SDS's actions. The necessity for the UCO's deployment or for the SDS as a whole was never properly considered. So I've set out in the written closing references to and examples of the evidence which clearly support each of these propositions. They are not in any real dispute, and I'm not going to repeat them today. But I am going to spend some time describing the evidence about sexual relationships. Some of this is disputed, such as in relation to knowledge and awareness of sexual relationships taking place. A detailed analysis is in the written closing. I will highlight a few key areas. First, risk of sexual relationships. There was an obvious risk of undercover officers in long-term deployments entering into sexual relationships. The MPS now accept that. Deployments of between 3 to 5 years from 1974 onwards meant sexual relationships would be expected of UCOs, and without a girlfriend, UCOs would face questions about why a young man seemingly had no interest in women. The likelihood of a sexual relationship was increased due to the amount of time UCOs spent undercover. Some UCOs worked 7 days a week for 14 hours a day and worked for weeks at a time, spending more time undercover in their cover identity than in their own real identity. Sexual relationships also offered a significant tactical advantage for UCOs and the SDS, both in terms of maintaining cover and obtaining more information. Thus, and counsel to the inquiry has already referred to this, Richard Clarke is believed by Mary to have used sex as a way of consolidating his history and to cement his reputation. She said he was using it to get closer to us as a group of activists, and it had the effect of allaying early suspicions about him in the tight-knit group. HN 354 Vincent Harvey said of his relationship with Madeleine that it's a sign that you're living a more normal life. It would dispel suspicion. HN 106 Barry Tompkins said, it was helpful for my cover for people to think I had a girlfriend. HN 304 Graham Coates explained that an individual in a sexual relationship with an activist is far more likely to be in a position to obtain valuable information. Not only was there an obvious risk of sexual relationships, but it is clear that deceitful relationships did occur. The passage of time since the T1 period, the fact that some potential witnesses are deceased, and the powerful code which enjoins officers to back each other up in the face of external examination, means it is not possible for the inquiry to be certain it has a full picture of what occurred. It is clear, however, that several UCOs in this period did have sexual relationships with women in their undercover identities. There's no dispute that Vincent Harvey had sexual relationships because he has admitted 4. One of those women has given evidence. That's Madeleine, and I will be giving her closing shortly. her evidence about the extent of the relationship differs sharply from his. There's equally no dispute that HN21 had a sexual relationship, because he too has admitted it. His original admission of 2 relationships has changed to 1, however, and it's not possible to corroborate his account of the relationship or its extent, because the woman or women have not given evidence. HN302 has also admitted to a sexual relationship, which he also claims was short-lived, but the woman involved has not been contacted to give evidence. HN155, Phil Cooper, has admitted dalliances and liaisons to his risk assessors, but has subsequently denied that he was admitting sexual relationships, claiming his comments had been misinterpreted and the interviews rushed. The risk assessors, in their oral evidence, have insisted their record of the interviews was accurate. The evidence also strongly suggests that Rick Clark, who is now deceased, had at least 1 and most likely several sexual relationships undercover. One of the women, Mary, has given evidence about a relationship with him and has also stated that her flatmate had a similar experience. Richard Chesham's evidence is that Rick Clark had sexual relationships with at least 4 women, and other officers have also given evidence that they heard about his relationships directly from him or via rumors. There's also strong evidence that HN300 Jim Pickford had a romantic and probably sexual relationship with an activist in his cover identity, which led to his deployment being terminated and to the end of his marriage. HN106 Barry Tompkins was believed by the security services and SDS managers to have bedded 1 woman and was thought by activists to be in a relationship with a second woman known as Barry's girlfriend. He denies being in a sexual relationship with either, but he admits a very close personal relationship with the woman thought to be his girlfriend. There is a dispute as to whether HN126 Paul Gray had a sexual relationship with Ross Gardner, who's deceased. Her fellow activist, Neil Hardy, has provided evidence suggesting that he did, but he has denied it. It is the Category H CP's case that the evidence shows that between 1974 and 1982, out of a total of 23 UCOs, 5 of whom are deceased, so they could not give evidence to the inquiry, at least 6 UCOs had 1 or more sexual relationships with female members of the public in their undercover identity. A further 7th UCO, Barry Tompkins, had an intimate romantic relationship with a female member of the public, which may well have been sexual and was perceived as serious by both the women involved and their circle of acquaintances. As for the rest, given the lacunae in the evidential picture, it's not possible to be sure whether any of the remaining 16 UCOs, 5 of whom are dead, had sexual relationships with female members of the public, but it's likely that some of them did. So the designated lawyers have asked you to draw a distinction between one-night stands and longer sexual relationships. I urge you not to do that, at least in this T1 era. That is because the claims of one-night stands are entirely uncorroborated. They may not be true, and that may not be how they were viewed by the women concerned. The only woman who has been able to give evidence in relation to such a claim has strongly denied it. That is Madeline in relation to Vincent Harvey. Moving on now to wider knowledge of sexual relationships by managers and others. The evidence shows that the risk that undercover officers would enter into sexual relationships was widely understood by undercover officers and managers at the time. It was also widely known that such relationships were likely to be taking place, even if undercover officers and managers did not know about specific relationships. Rick Clark's sexual relationships, as I've already mentioned, became the subject of widespread knowledge in the SDS after his undercover identity was exposed as false in 1976, and he had to be withdrawn from deployment. And a number of UCOs and managers also came to know about HN300 Jim Pickford's withdrawal from deployment in 1976 after he fell in love with a female member of the public whom he later married. So there are 3 managers who have acknowledged knowing about the risk of relationships: Superintendent David Bicknell, Detective Inspector Angus McIntosh, and Chief Inspector Trevor Butler. In addition to these acknowledgements, there's evidence that Chief Inspector Mike Ferguson, who is deceased, also knew of the risk because Angus McIntosh said that he did. Nor was the risk known only in the abstract. In oral and written testimony, Graham Coates said that there were jokey remarks made in SDS meetings about sexual encounters with women whilst undercover, including some of a gross kind, such as the one that I have mentioned already. And he also said that jokes about Richard Clarke and his sexual activities were common in the safe house with SDS managers' knowledge. Those comments in the safe house in the 1976 period left him in no doubt that the management were aware of Rick Clarke's behaviour. In oral evidence, Graham Coates stated he was confident that the contemporary management of SDS Chief Inspector Derek Neal, Inspector and Chief Inspector Jeffrey Kraft, Sergeant HN 368 were aware of those jokes about Rick Clarke's sexual relationships. He also said that he believed Angus McIntosh would have been aware, as he joined the SDS in 1976, shortly before Rick Clarke was compromised. The Cat H CPs submit that Graham Coates's oral and written testimony is honest, candid, consistent, and plausible, and in keeping with the findings of the contemporary PSI report. It's also supported by the following evidence. Rick Clarke openly boasted about his sexual exploits to other undercover officers. He had an established reputation as a womanizer. An officer enclosed has described how it became common knowledge that Rick Clarke had engaged in sexual relationships leading to his compromise in 1976. When asked about managers' knowledge, he said, "I wouldn't know if they knew or if it was just a rank and file thing. I should imagine that some of them did." When Paul Gray joined the SDS in October 1977, he raised concerns about the use of a deceased child's identity after Rick Clarke's compromise. He was reassured by SDS management, he said, that he would not be compromised in a similar way because Rick Clarke's sexual relationships had been the cause. The detective inspectors and chief inspectors in post at that time were Jeffrey Kraft, Angus McIntosh, and Kenneth Pride. Among those managers, as Angus McIntosh accepted, there were no secrets professionally. Finally, sir, the Rick Clarke matter became infamous and was documented in the SDS Tradecraft Manual. It is implausible that an event so notorious was known to UCOs, but unknown to those managers who had to deal with the fallout in real time. In the same year as the Rick Clarke matter, as I've already indicated, Jim Pickford was withdrawn from deployment. He had confessed to his UCO colleague that he'd fallen in love. That colleague reported the matter to the office, and that colleague has also given evidence that Angus McIntosh met the undercover officer in the pub. The premature withdrawal of Jim Pickford was the second significant withdrawal in the SDS within 3 months and must have been a matter of considerable note. There are also minutes from a meeting between the security services and the SDS from 29th of June 1981, which confirmed that Chief Inspector Dave Short was aware that Barry Tompkins had probably bedded an activist. At the time, Jeffrey Kraft was Chief Superintendent of S-Squad with responsibility for the SDS. All of this indicates wide knowledge. Notwithstanding all this evidence, several SDS managers have denied they were aware of the risk of sexual relationships and have also denied that they were aware of actual or suspected relationships of Rick Clarke, Jim Pickford, and Barry Tompkins. The Category H CPs submit that these denials do not withstand scrutiny. Given that the risk of sexual relationships is obvious and inherent, it is simply not plausible that some UCOs and managers in a position of responsibility, like Angus McIntosh and Michael Ferguson, were aware of that risk, and some, like Geoffrey Kraft and Barry Moss, were not. Geoffrey Kraft's denials of awareness are particularly implausible because they involve accepting that an inspector who was for a whole year directly answerable to him, Angus McIntosh, and a detective chief inspector who took over his role shortly after Geoffrey Kraft relinquished it, that's Michael Ferguson, were both aware of or involved in discussions about the issue of girlfriends, but he was wholly unaware of them. There are a number of other seriously problematic aspects of the evidence of senior managers, Geoffrey Kraft and Angus McIntosh, including their claim that they do not recall serving alongside each other for a year between 1976 and 1977, even though the evidence shows beyond doubt that this is what occurred. I've addressed this in the written closing and do not repeat it here, save to say that these claims, alongside both men's evidence that they were unaware of the widespread common understanding in the SDS that Rick Clark's sexual relationships led to his compromise, and their evidence that they also did not know why Jim Pickford was withdrawn, are incredible. They should be rejected. As for Trevor Butler and Barry Moss, both men took over management of the SDS in 1979 and 1980, and for the reasons set out above, they cannot have been ignorant of the obvious risk of sexual relationships or kept in the dark about the scandalous events of 1976, which showed that the risk was not merely theoretical. Trevor Butler, furthermore, is very likely to have been aware of the security services recorded belief that Barry Tompkins had bedded an activist because he was chief inspector of the SDS at the time, and Barry Tompkins recalls a conversation with him, notwithstanding Butler's denials. No meaningful steps were taken to combat the known risk of sexual relationships. Even after Rick Clark and Jim Pickford were withdrawn in 1976, there was no evidence of guidance or training to officers to avoid sexual relationships, nor were any other measures taken. Undercover officers were not advised or provided any guidance about avoiding sexual relationships while undercover. At best, they were advised euphemistically to be careful and take precautions. SDS managers have confirmed that they did not give officers advice about sexual relationships while undercover. Barry Moss said it might have been a good idea, but he did not give advice on how to avoid sexual contact. Geoffrey Kraft appeared unable even to conceptualize what such guidance would have looked like. When he was asked about how to prevent officers engaging in sexual relationships, he said, "All I can say is that perhaps it needs to be emphasized regularly before it starts and also regularly while the operation is continuing, because I don't think there is any way of preventing it, because these things happen, but it is a problem." Angus McIntosh said, "I would have thought that if they were having a problem with this particular aspect, they would approach either myself or the DCI to discuss the problem and the way forward." In addition to the lack of guidance, there was no support to develop cover backgrounds and legends which might alleviate the risk of sexual relationships. In practice, undercover officers chose their cover identities alone, without assistance. Trevor Butler said that he did not consider providing cover girlfriends to his officers. Angus McIntosh gave evidence that there were discussions within the SDS about how to deflect suspicion about UCOs not being in a sexual relationship with a member of the group. There is a restriction order covering the content of these discussions, but in oral evidence, they were described as responsive to, quote, "the crisis at the time." So there were also no meaningful sanctions once sexual relationships occurred. In relation to Jim Pickford, Angus McIntosh said the matter would have been reported all the way up, but he did not know if disciplinary action would have been taken. He said all the circumstances would have to be considered, and it could have happened. The senior management may have felt the circumstances were such that it wouldn't be a discipline. Geoffrey Craft suggested it may not be possible to discipline an SDS officer to avoid compromise of the SDS. When asked by you, sir, if Rick Clark would have been considered for disciplinary action if his sexual relationships became known, he said, "The only caveat on that, sir, is bearing in mind his rights. Should there be a discipline board, what would he have said? What might have been published? We were operating in a top secret area, and I can't honestly say what decision would have been made about that." A similar remark was made by Barry Moss. And Trevor Butler said that he didn't know if there would be disciplinary action as it was above his pay grade. So I want to turn to conclusions. The Category H core participants reiterate their position as set out in their opening statement for Phase 3 and the accompanying legal framework. They submit that the use of undercover policing by the SDS was unjustified, unlawful, and profoundly anti-democratic. It seriously violated fundamental rights at common law and human rights law. Both common law and human rights law contain strong protections for people against state interferences with their homes and for their fundamental democratic right to protest and join political groups. And I've set out the law in the legal framework and in those submissions. So the need to maintain public order at demonstrations could not justify the inroads into democratic values and private common law rights caused by extensive undercover surveillance. There is no case which comes close to suggesting invasive powers like these could be used to police public order more effectively. Even where crime is concerned, the common law does not permit police officers to ransack anyone's house or to search for papers or articles therein, simply to see if he may have committed some crime or other. Nor does the common law permit untargeted, indiscriminate searches. The courts have said the aversion to general warrants is one of the basic principles on which the law of the UK is founded. Nor can interferences be justified because the intelligence gathered by SDS UCOs was shared with the security service. As counsel to the inquiry has explained, the activities of those spied on did not even meet the definition of subversion, let alone pose any kind of imminent risk. The Category H CPs consider that the MPS's interferences with fundamental common law and human rights were particularly serious and dangerous because they opened the gateway to sexual abuse of them. When they unlawfully entered people's homes and private lives, the MPS took the misogyny, which corrupted the entire organization, and transported it directly into the private homes and private lives of women. These were women who were entitled to believe they were safe in their homes and private circles of friends and acquaintances. They were entitled to believe that their homes were their castles and that in a potentially dangerous world, they were making autonomous choices about who to invite into their lives and private spaces, who to trust. In reality, the MPS was making that choice for them. And instead of choosing officers who would respect the women they encountered, and instead of taking all necessary precautions to counter the obvious risk of sexual relationships, both the MPS and the men sent into their lives had contempt for them. These men were nurtured in a cult of masculinity in which women were slags or split asses, and police officers were sexual conquerors triumphing over women. Gross and lurid language about sex and women was commonplace. Some UCOs were notorious womanizers. The attitudes of senior officers were little better. Further, to this day, many of those responsible for the SDS in Tranche 1 do not accept that any wrongs were done to the women with whom UCOs had sex. They have given evidence making plain they do not accept it is abusive for the police to use sex with women to assist them to gather information. In these circumstances, it is no surprise that neither UCOs nor senior officers inside or outside the SDS paid any regard to the dignity or bodily autonomy of the women they spied on. It is no surprise that no meaningful steps were taken to avert the obvious risk of sexual relationships, either before it first materialized or after it became clear that they were taking place. It is no surprise that women were used casually by UCOs according to their personal preferences or the perceived exigencies of their deployment to maintain cover, gain access, or obtain information. And it is no surprise that after being used, these women were the subject of bawdy talk or gross banter among UCOs in the hearing of senior officers who tolerated it and turned a blind eye. It is no surprise because this was part of police culture. The Category H CPs do not consider it remotely plausible that the manifestly obvious risk of sexual relationships was known to and considered by only junior police officers and their immediate superiors in the SDS. Any police officer, official, or minister who knew that officers were being sent undercover with false identities and cover addresses for 4 years at a time knew about that risk, and they must also have known that no meaningful steps were being taken to meet it. Finally, the Category H CPs wish to address the attitudes of the MPS to the public and to this inquiry. As explained above, despite all the allowances made for them, including evidence enclosed, protection of their real identities, and the Attorney General's immunity, some police officers, including senior officers, have not told the whole truth to this inquiry. They have continued to prioritize the powerful code of backing each other up over the right of this inquiry and ultimately the public to discover the truth about what went wrong with the SDS in Tranche 1. The them and us culture of the MPS, pitting internal police interests against the public they are supposed to serve, is deeply corrosive. It is the antithesis of the Pelian principles, and in particular, the antithesis of the principle that the police are the public and the public are the police. The public expected and had the right to expect that the police would uphold law and order and the values of truth, integrity, and honesty which underpin law and order, just as they, the public, are expected to do. In the Tranche 1 era, the police undermined these values and betrayed the public trust. The public now have the right to expect the MPS will tell this inquiry the whole truth. Not all have done so. That is deeply disappointing. The Category H CPs consider that the endemic misogyny in the MPS, the culture of them and us, and the culture of law breaking has to be eradicated for the safety of the public. As the crimes of David Carrick and Wayne Couzens have shown, these attitudes and the tolerance for them in the MPS have horrific consequences for women. They can literally be a matter of life and death. They hope and trust that the inquiry will recommend that the long overdue process of eradication will be prioritized and urgently progressed.
Thank you very much. As you have in fact stuck precisely to your timetable for your first submission, I hope that you would now like to have the 10-minute break which the timetable affords you.
I would. Thank you very much.
Good. Thank you. Ms. Kilroy.
So I'm now going to give the oral closing on behalf of Madeleine. Madeleine adopts in full the oral and written closing of the Category H CPs. That closing is of particular relevance to her. She is one of the women with whom undercover officers in the Tranche 1 period are known to have had deceitful sexual relationships. Due to difficulties in tracing and contacting other women, or because they are deceased, she is one of only 2 women who is given evidence about sexual relationships in Tranche 1. She submits that her experiences exemplify many of the themes in the Category H closing, including the deep intrusions into homes and private lives to which law-abiding members of the public, like her family, and her friends were exposed as a result of the SDS's unlawful and unjustified operations. The risks and dangers to which women were exposed, the consequences for women of the cult of masculinity, which I've just been talking about and which was identified in the PSI report, and the limited reliability of some police officers' evidence due to the powerful code of backing each other up. She says all those factors are present in her case. In this closing, I'm going to describe those experiences and the conclusions that she draws from them. She has given 2 witness statements, and she's also given oral evidence in which she has detailed the political activism which began in her early teens and continued into her 20s, inspired by her parents' experience of extreme poverty and of war and their strong anti-fascism. She's also explained the anti-war, anti-fascist, and anti-capitalist beliefs, which led to her joining the International Socialists and later the Socialist Workers' Party at 14 or 15 years old, in order to create a fairer and more equal society. She has told how, as a bus conductor in her 20s, she was a trade unionist in the Transport and General Workers Union, sitting on a regional women's subcommittee. Following that, her political activism waned, and she retrained as an artist, teaching in schools and community groups. It is plain from her evidence and from that of the UCOs who spied on her that Madeleine has never been involved in any violence, was never arrested, and never convicted for a criminal offence. Despite this, the evidence shows, and the counsel to the inquiry mentioned this yesterday, that in 1970, when still a child of 16, Madeleine had a special branch registry file. Vincent Harvey, alias Vince Miller, cipher HN354, was deployed into the SDS from late 1976 or early 1977 until 1979. He infiltrated the SWP Socialist Worker Party Walthamstow branch. He has provided the inquiry with 2 written statements and oral evidence in open. Vincent Harvey was friends with Rick Clark and HN21, both of whom had sexual relationships in their cover identities. In 1977, by the time Madeleine was aged 23, Vincent Harvey was infiltrating her home and private life in his covert identity. For the next 2 years, while frequently attending public SWP meetings and private gatherings at her home, Harvey produced regular secret reports relating to her and others, which were shared with the security service. The reports included physical descriptions of her and details about her family relationships, her political beliefs, and her occupation. In 1979, by the time Madeleine was 25, Vince Miller, as he was known, started a sexual relationship with her, which lasted around 2 months. The relationship had a deep emotional impact on her for some time. It was one of 4 sexual relationships he's admitted to while undercover. After he was withdrawn from his deployment, in the autumn of 1979, pretending to have gone to the USA, Harvey went on to assume senior roles in the police force, including leading Operation Pragada, an investigation into child abuse at Lambeth Children's Services, and becoming National Director of the National Crime Intelligence Service. In relation to the operations of the SDS, Madeleine relies on the evidence summarized in the Category H written closing at paragraphs 47 to 74, and she adds the following about the evidence specific to the deployment of Vincent Harvey. Vincent Harvey had not been tasked to infiltrate either the SWP or the branches Madeleine was a member of, or Madeleine herself. He was asked to observe and then become involved in an active subversive group that was of interest to Special Branch. He chose the targets of his operation himself and used his own judgment about what to report. His role was to gather both information and intelligence regarding potential public order problems and activities defined as subversive by the security service. He wasn't provided with any other information about the intended targets of his work. Harvey's tasking was not changed or refined at any point during his 3-year deployment. He worked 7 days a week, 14 hours a day, and earned substantial overtime. Harvey viewed his position as treasurer of SWP committees and branches as a fantastic opportunity, and he used this position of trust to gather financial information on members, including bank details, addresses, occupations, and living arrangements. He then reported this information to the SDS, expecting that it would be of use to the security service. He also reported information about children because the SWP had youth movements, and he considered the information important to Special Branch and the security service. The SWP branches that Madeleine was involved with engaged in entirely open and lawful political activities whose central aim was to create a fairer society. They held weekly public meetings, they sold newspapers in public, they attended demonstrations in public, and some members joined trade unions. Madeleine has made plain that neither she nor her fellow members supported violence in any shape or form, and that they were strongly opposed to any form of terrorism. Julia Pointer, who was a fellow SWP activist in the same group, has confirmed this in her written evidence. Vince Harvey himself explains that a general strike rather than violence was the mechanism envisaged by the SWP for achieving change, although he said street violence was permissible against the fascists. And he agreed that acts of individual violence were positively discouraged by the SWP. He explains that even when attacked by the National Front, few SWP members would engage in violence. The evidence suggests that disorder and violence involving the SWP, when it occurred, was instigated by the National Front, took place at events organized by them, and was therefore predictable. Where violence was envisaged in self-defense against the National Front, there was often a great deal of rhetoric and language that was much stronger than action that followed, in his words. Madeleine and her fellow SWP members did not believe revolution was imminent and did not think they could overthrow any part of the state. In terms of a revolution, there was an awful lot talked about and very little action in that direction. They were far more interested in building the working class movement and sought instead to raise awareness in the working class and build a mass movement through their campaigning activities, including selling papers, trade union activities, and protests. Much of the benefit of SDS intelligence was cumulative rather than related to individuals. It was confirmation of an absence of risk rather than a presence of risk, and it was said to have permitted accurate deployment of police resources at demonstrations. Vince Harvey had several sexual relationships, as I've already mentioned. He said he was in a long-term relationship when he was deployed, and that the relationship ended during his time with the SDS, but he nonetheless said he had 4 sexual encounters with 4 different women. Madeline, a member of SWP, and 2 women who were not members of SWP, but were what he called friends of friends. He initially said that these were all sometime after he'd split up with his previous long-term partner, but was not sure of the timing of these encounters, and he said his memory of that time is not that clear. He later accepted that 2 sexual encounters took place at the start of his deployment when he was still in a relationship. Harvey met Madeline in 1977 and regularly visited her house after meetings. Madeline recalls their sexual relationship beginning probably at the end of summer '79 and continuing for 2 months. He initiated a relationship during a party. He told Madeline that he had had his heart broken by his former fiancée, and as a result, he had closed down emotionally and kept women at arm's length, and he had a difficult childhood. Madeline said these stories elicited feelings of sympathy from her. She recalled him leaving in the early hours of the morning as a pattern of behavior. Her flatmates knew, and everybody knew, that there was something going on between them. Her feelings grew stronger and she hoped they would become a couple, but he started to withdraw, blaming the past traumatic relationship. Soon afterwards, he disappeared altogether, claiming to have left for the USA. She was very upset. Madeline's account is corroborated by Julia Pointer and also an entry from a friend's diary, which refers to Vincent Harvey as Madeline's ex-lover. This is a contemporaneous diary. Harvey's recollection is that he had sex with Madeline only once. He was single and in my 20s at the time, had to mingle and network socially and consume alcohol in order to maintain his cover. He, as he described it, was living a strange double life and did not think he was putting anyone's feelings at risk. As a single man in his 20s, he said, it would have appeared odd to have acted otherwise, and people would expect you to have some kind of relationship. A byproduct, as he put it, of his relationship with Madeline was that it discouraged advances from a gay man who was becoming persistent. Vincent Harvey said that he did not use stories he told Madeline about his background as a ploy, but as a cover story for protection. He did not think about the effect it might have on women. He said that the idea of sending a postcard postmarked from the USA after he left his deployment was a supervisor's idea and not his own. He also said he did not tell his colleagues or managers or anyone else about the one-night stands he had because he didn't attribute it much importance. And he finds it very difficult to answer whether sexual activity in his cover identity was permitted. He does not recall guidance for sexual relationships and suspects it was left to his own judgment how far to become involved in the private lives of those he met undercover. Although he does say that HN34, that's Jeffrey Kraft, told him not to start a relationship with Julia Pointer. He accepts it was morally questionable for him to have had a relationship with a member of the public, and that Madeline would not have had a sexual relationship with him had she known that he was an undercover police officer. Madeline has confirmed she would never have done so. He says that stricter guidance and firmer supervision would probably have led to him making different decisions on sexual relationships. Vincent Harvey also says he didn't use contraception with Madeline because my perception was that as a full feminist socialist supporter, then if there was any need for protection, she would have mentioned it. This was a member of the women's movement and things like that. He also did not use contraception with the 3 other women he had sex with for the same reason. He did not accept when he gave evidence that Madeline was betrayed, vulnerable, and disgusted by his actions. He said that, I think my feeling was that she wasn't overly concerned by the situation, and therefore betrayal seems a little over the top. Vincent Harvey accepts that Madeline's evidence that their sexual relationship continued for around 2 months and included sexual intercourse approximately once a week is genuine evidence, but he claims he has a different recollection. Harvey also claims his other sexual relationships were one-off events. The first 2 were, he made clear in his oral evidence, at the start of his deployment with women he met in very casual circumstances. His evidence changed, but in oral evidence he said of the first one, it was someone else I'd met in a pub trying to establish some sort of local knowledge. The pub had other people in there. You get introduced. not my greatest moment. The second sexual encounter was in very similar circumstances. Of the third, he said he had met her at the beginning of his deployment, saw her at SWP callouts and socially. They had been, he said, very good friends, and they had a sexual relationship one evening after a party at the end of his deployment. He did not think she would have had a sexual relationship with him if she knew that he was a police officer. Harvey said that he cannot recall hearing sexual banter among UCOs, and although he knew that a number of UCOs who were in the SDS before, alongside him, and after him had reputations as womanizers and had engaged in sexual relationships undercover, he says that he only realized this after he left the SDS. He also said he is unaware that the management ever knew of any such relationships. Vincent Harvey was managed by 3 police officers, Geoffrey Craft, Angus McIntosh, and Trevor Butler. Madeleine relies on the analysis of their evidence in the Cat H closing and highlights the following. All claim not to have known that Harvey or anyone else had sexual relationships with members of the public. They describe exercising close supervision over undercover officers, but deny knowledge of undercover officers engaging in intimate relationships. She submits this evidence is not credible. All 3 managers were aware of the obvious risk of undercover officers engaging in sexual relationships, and it is not plausible that they were not also aware that such relationships had, by the time of Vincent Harvey's deployment, taken place. Rick Clark and Jim Pickford had both just been withdrawn from deployment in 1976, before Vincent Harvey was deployed, and it was common knowledge that both had entered into sexual or romantic relationships with women they spied on. Madeleine adopts the conclusions of the Category H written and oral closing. For the reasons they set out, she submits that the actions of the SDS and Vincent Harvey in respect of her and the SWP branches of which she was a member were unlawful, unjustified, and deeply abusive. She highlights the following. Vincent Harvey was sent into the field to pose as an activist and operate undercover for 4 years without even having a target or organization to infiltrate, still less an identified individual. He was left to exercise his own judgment on who and what to report on, when and where to conduct his surveillance, and how much or how little to interfere into private lives and homes for 3 years. His deployment only ended because he was promoted. There was no pressing need for any invasive surveillance of either Madeleine or her fellow SWP branch members, still less a pressing need for invasive surveillance of this depth and length. Neither Madeleine nor her branch of the SWP had been identified by the SDS as a target. She had not committed any crime, nor did she pose any imminent threat of breach of the peace, which could justify the deployment into her life and home. Once deployed, Harvey's surveillance confirmed this lack of criminality and lack of any imminent threat of violence, and yet the invasive surveillance continued. She also highlights that the use of covert powers is subject to a particularly strict necessity test, both in terms of the seriousness of the threat said to justify their use and the need to show the lack of any alternative method of meeting that threat. This strict test was obviously not met in the case of Madeleine and the Walthamstow and Leighton branches of the SWP. Most seriously of all, in her case, and in the case of at least 4 other women, these serious violations of fundamental rights were compounded by the abusive sexual relationships to which all these women were exposed when a male UCO was sent into their private homes and lives. Madeleine submits that given the lack of any proper justification for her surveillance in the first place, this amounts to a particularly egregious violation of her rights. She agrees with the Category H submission that the failure to take any steps to protect women in the wake of Rick Clark's withdrawal from deployment indicates tacit acceptance that sexual relationships would occur. Given the timing, it had an immediate adverse impact on her. She also submits it is clear from Vince Harvey's evidence that he treated his deployment as a sexual opportunity from the start, and he made full use of that opportunity as soon as he was deployed. According to his own evidence, he was still availing himself of these sexual opportunities right up until his deployment finished. He also put women at risk, given his multiple partners and failure to use contraception. Harvey's casual and contemptuous use of Madeline's body and emotions for his own ends, as he explained, he didn't attribute it much importance, was inhuman and degrading treatment of her by him and all those responsible for his deployment, which can never be justified. Madeline also submits that Harvey's evidence on the following matters should be rejected as untrue. Harvey's claim that he did not hear sexual banter among UCOs. Harvey's assertion that he only realized Rick Clark and Jim Pickford had sexual relationships after they all left the SDS. And Harvey's statement that he's unaware that the management ever knew of such relationships. Madeline submits this evidence cannot be accepted as credible, given that the evidence of Graham Coates, Geoffrey Craft, and Angus McIntosh about the prevalence of sexual banter, which is strongly corroborated by the PSI report, given also the widespread contemporaneous knowledge among UCOs of Rick Clark's sexual relationships and reputation as a womanizer, and finally, given that Rick Clark was Harvey's friend and that he was compromised while Harvey was deployed. Madeline submits that Harvey's claim that it is his recollection that he had sex with Madeline only once should also be rejected as untrue and as an attempt to minimize his conduct. Given this and his changing account of the timing of his relationships, his evidence that his other sexual relationships with one-night stands should also be treated with caution. In her opening statement for Tranche 1 P3, Madeline highlighted that it was as a direct result of the SDS's departure from basic common law and human rights principles that she was put at risk of being abused by Vincent Harvey. She pointed out that had the SDS's invasive tactics been reserved for serious crime or imminent violence, had Harvey been given proper targets and tasking, and had there been tight boundaries, clear guidance, and adequate supervision, she would have been safe. There is a further critical factor which put Madeline at risk. It is revealed by the PSI report highlighted in the Category H closing and the evidence of Graham Coates. The MPS was, as I've already described, in the T1 era, and it remains to date, a deeply misogynist organization dominated by a cult of masculinity. By sending UCOs with these attitudes into the homes and private lives of Madeline and other women, the MPS's most senior officers put women at direct risk of predatory and abusive behavior. This was, as I've already described, the place where they were entitled to believe they were safe, in their homes and amongst private circles of friends and acquaintances. The MPS did nothing at all to avert that risk. The only thing that was averted was the gaze of the most senior officers when they decided to turn a blind eye. To this day, the senior officers responsible for Harvey, Geoffrey Craft, and Angus McIntosh do not even consider his conduct abusive. Madeline makes clear she considers the conduct of the entire MPS, not just Vincent Harvey, unforgivable, and she holds them and the cult of masculinity directly responsible for her mistreatment and for the mistreatment of all the other women abused by the SDS. She hopes that she and all of the affected women will soon receive a full and open apology from the MPS for the endemic sexism, which was the driving force for the abuse which they have all suffered, and a straightforward public commitment to eradicating misogyny and sexism in all its forms from the MPS's culture. Finally, she has a specific request to you, sir, that any reference to Vincent Harvey in the inquiry's reports be made, including all the names he's been known by. In other words, his real name, Vincent Harvey, as well as his alias, Vince Miller, and his cipher, HN354. This is because she wants to ensure he is visible and unable to hide behind ciphers as he's held to account by this inquiry.
Thank you. I'm afraid I will not be able to fulfill that last request, one of the reasons we adopt ciphers is to ensure that we do not inadvertently step over the line between real and cover identity where there are restriction orders in place. And I'm afraid it's a habit that has got ingrained, and I'm afraid it will remain so. But everyone knows the real name of the officer concerned. It has been put into the public domain, and in other circumstances, other officers' real names have been put into the public domain for similar reasons. Are you now ready to go straight on to Diane Langford?
That's right. So if that's all right,
Of
I'll
course
move
it is.
straight to Diane Langford's oral closing statement. So, like the others for whom I have given oral statements today, there is a written closing statement. I'm going to follow that statement, but not all of it in my oral submissions today. Can I start off by addressing Miss Langford's background as a political activist and campaigner throughout her life? Diane Langford was born on the 21st of November, 1941 in New Zealand. Her experiences there shaped the principled political activism which has been a feature of her life ever since. As a child, she witnessed firsthand the unfairness and brutality of colonialism and racism towards Maori Indigenous communities. Her brothers were meanwhile given a university education, whereas as a girl, she was expected to leave school at 15 to work in a Kodak factory. She was later sent in 1963 to London, not for her own education, but to support her younger brother, who had won a scholarship at the Royal Academy of Music. Consequently, following her arrival in London, she volunteered at the Campaign Against Racial Discrimination until 1969, became a member of the print union NATSOPA in 1967, and joined the Britain-Vietnam Solidarity Front in 1968 to protest against the excesses of the Vietnam War. In 1970, she co-founded the Women's Liberation Front and also set up the Women's Equal Rights Campaign. She became involved in the Palestinian Solidarity Campaign in 1970, and from 1974 to 1996 was Mother of the Chapel, which is a shop steward for the union, the Society of Graphical and Allied Trades at the Press Association. She is now 81 years old. While her politics has developed over the past 50 years, her priorities remain the liberation of women from all forms of oppression and exploitation, supporting self-determination and freedom from occupation and apartheid for the Palestinian people, and movements for justice for other dispossessed or marginalized people. All of this is set out in her witness statement. As she says, I continue to organize around issues such as anti-racism, the women's liberation movement, the Palestine Solidarity Campaign, the LGBTQ movement, trade union and worker rights, support for the NHS against privatization, nursery campaigns, support for the disabled people's movement, in defense of local services, etc. Ms. Langford has never been involved in any criminal activity. She explains, all my activism has always been open and through the usual democratic means, from lobbying the government to attending demonstrations. I have never been arrested for a criminal offence. Nor did Ms. Langford's activities pose any threat to public order. She has never been involved in any violence. Ms. Langford considers that her lifelong commitment and the commitment of fellow members of the groups she was part of to using debate, protest, and lawful means of community organization and persuasion to transform the social and political system is emblematic of a healthy democratic system. As her evidence records, members of various groups would debate vigorously the best method of achieving change, with vehement language sometimes used. Some ideas were more palatable than others, but such open exchanges of views and the moderation achieved by debate and difference of opinion are the lifeblood of democracy. They do not in any sense undermine democracy, nor do exchanges of ideas merit surveillance by the state. So while her activism and her commitment to debate is emblematic of democracy, the same cannot be said of the activities of the Metropolitan Police Service and the SDS. The disclosure made by the inquiry shows that while Miss Langford, her friends, family, and acquaintances were engaged in the entirely lawful activities I've just been describing, she was the subject of detailed surveillance by undercover officers posing as fellow political activists. The surveillance lasted for at least a 10-year period between July 1968 and January 1979, and it appears to have been particularly intense between 1969 and 73. 7 UCOs infiltrated her private life in various capacities and reported on her during that period. They spied on a wide range of her political activities, including for the Women's Liberation Front and the Palestine Solidarity Campaign. The surveillance was detailed and intrusive, with undercover officers regularly entering her home, attending private social gatherings and political meetings, and recording detailed information about her political views, family arrangements, marriage, and employment. They then stored and shared this private information with other police officers and the security service. Their reporting was often accompanied by inappropriate personal commentary on Miss Langford's views and family arrangements. The evidence adduced in Tranche 1 shows that Miss Langford's political activities were the subject of intense and long-term surveillance by these 7 UCOs. Now, she has attempted, for the assistance of the inquiry, to put this reporting in context in her statement, although, as she explains, she's not had access to all the information which would enable her to comment most effectively, including photographs of UCOs, which would allow her to recall them. The surveillance and reporting of 2 of these officers, HN 348 and HN 45, was particularly intrusive. HN 348 infiltrated Miss Langford's life for 2 years, spying on WLF meetings, and HN 45 for 3 years, with both attending private meetings in her home and the homes of fellow activists, and compiling dozens of reports containing detailed information about her political views, that of her husband, Abhimanyu Manchanda, and about their private family life, including their childcare arrangements. Miss Langford was also spied on intensively by 3 other officers, HN 135, HN 336, and HN 335 between 1969 to 70, including at private meetings and at her home. HN 348, Sandra Davis, confirmed that the meetings of the WLF she attended were often held in private homes. She told her senior officers about this and says there was no suggestion I should not attend because the meetings were held in those homes. She was also not given any guidance not to report private or personal details that she had observed there. The groups which HN 348 infiltrated held meetings and engaged in leafleting and demonstrations. Their activities were all within the bounds of the law. As HN 348 put it, the political ideology they were promoting did not spill over into what they were doing. These events were intimate, social, and refreshments were provided. It's likely that HN 348 took on the role of treasurer of the WLF on the 6th of February 1972, was closely involved in the work of the WF, and that she was also regarded as a central member of it, as well as a friend, even though she was, in reality, an undercover officer. HN 348 was not aware of any criminal activity, and there was no record of public disorder by Miss Langford or any other WLF members, nor were any of them arrested. She observed that WLF were more talk than action, and for the entirety of her 2-year deployment, she did not see any subversive or disruptive or violent extremist behavior. She said she was tasked to observe them because Special Branch did not know much about them and wanted to find out what was really happening. Her tasking to infiltrate the groups was broad brush and ad hoc, although on occasion she appears to have received specific requests for information from the security service with which she complied. HN 348 did not think her undercover policing was worthwhile, and she queried whether police officers should be undercover at all. As for HN 45, he was given the broad task of infiltrating Maoist groups, which groups were a matter for him, and he had fluid membership of lots of groups. He explained that the SDS was trying to find out whether these groups posed a risk to public order, and the security services also had an interest in gathering information about any risks posed to state security. There was no clear next step once a UCO like him got connected with a group. They were expected to use their initiative, discretion, and judgment, but HN 45 would not have reported on matters that did not fall within my broad remit. He knew his role was to gather as much intelligence as he could on his target groups and pass it back to the SDS. And so he reported on names, occupations, addresses, and positions of all members of the groups without selection. One of his main jobs was to find out about membership of protest groups. He said the security services were interested in everything, and you did not ask questions about why they wanted certain information. He also says that the Maoists were generally not violent, and he does not remember them being engaged in public disorder. Nor did any of the other groups he spied on pose any particular threat to public order or to the state. As for subversion, he says they were subversive in the sense that their whole purpose was to subvert the political system, but they could not actually achieve this, as they did not have the means to do so, and they were largely pretty ineffective. HN 45 admits he was closer to Diane Langford and Manchanda than to other activists, and he claims to have been sufficiently close to have babysit their child. Miss Langford agrees he socialized regularly with them, but denies the babysitting. HN 348 and 45's reports frequently contained information on intimate private matters and social commentary that was racist, sexist, or homophobic. Recording this information served no conceivable intelligence purpose, and yet the UCOs considered it was their function to record such intimate details and convey their views on it to their superiors and the security service. Some of the information appears to have been recorded for amusement value, and it illustrates the sexist, prurient, and contemptuous attitudes of the UCOs to those spied on. Just by way of example, in relation to Miss Langford's childcare arrangements, HN 45 stated, sarcastically, Manchanda considers that this is a practical experiment in the field of women's liberation, as he remains at home to look after their young baby born in December 1970, while his wife is out working. HN 348 recorded the following about a women's liberation conference in 1972. Lesbian friends in particular made exaggerated and noisy displays of affection, openly kissing and hugging each other. These displays were commonplace throughout the conference, and it was not unusual to see two girls entwined in a corner. That little notice was taken by the majority of women present indicated the prevailing liberal attitude. Both HN 45 and HN 348 were withdrawn from deployment in 1973 when HN 45 was recognized by Ethel as a police officer. In fact, Miss Langford says she already strongly suspected him, but his violence and threats towards Ethel, which he denies, exposed to her the sinister nature of his role. It appears that HN 45's compromise led to a significant diminution in SDS's reporting on Miss Langford's political activities, which confirms that there was no proper need for it in the first place. Other significant reporting, as I've already mentioned, was carried out by HN 336, 135, and 335, with Miss Langford's report appearing in multiple reports from all these officers between 1969 and 70. The targets of HN 336 and 135 were the BVSF and VSC, whereas HN 335 infiltrated the PSC. In conclusion, Miss Langford adopts the general submissions of the Category H CPs in their written and oral closing. As for the surveillance of her, it is Miss Langford's position, which she invites the inquiry to adopt, that the police's surveillance of her was unjustified in every sense. They had no right to be in her home, and they were trespassing there. There was no crime to investigate, and they had no lawful authority. They had no right to record details of her family life or her views expressed in the privacy of her own home or the homes of others or at private meetings. There was no pressing need to do so, even if she had posed a risk of public disorder. But she did not pose such a risk, nor did she pose any risk of subversion. She also asks the inquiry to confirm that her political views and family arrangements were and are private and no business of the police or the state. She considers that her right to her views untrammeled by surveillance or interference by the state, secret or otherwise, is a linchpin of a democratic system and a key distinguishing feature between democracy and totalitarianism. As I've already indicated, the activities she was involved in were a prime example of what democracy at its best permits in order to achieve beneficial change in society. There was nothing dangerous or subversive about them at all. Indeed, counsel to the inquiry has also said in his closing yesterday that the Women's Liberation Front championed equality of opportunity, equality of pay, access to childcare and fair divorce arrangements, and yet it and Miss Langford became a target for intrusive surveillance for almost 2 years. Miss Langford submits that the actions and attitudes of the MPS and the STS resembled those used by totalitarian states to spy on political opponents. They had little or no respect for the law, for her, or for the fundamental rights of any of those spied on. Instead, the SDS was unaccountable and a law unto itself. Consequently, it seriously undermined and damaged the democratic values which it was its function to uphold. Ms. Langford also finally notes further features of the Category H closing which have particular relevance to her. The widespread misogyny and sexism revealed in the Policy Studies Institute, the PSI report, explains the sexist and racist attitudes pervading the reporting of HN 45 and HN 348. They also appear to have at least partly motivated HN 348's deployment. The Women's Liberation Front, as I've already said, posed no conceivable threat to either public order or the state, but it seems the SDS and security services assumed it was controlled by Ms. Langford's husband and infiltrated it for 2 years, at least in part for that reason. She makes that point at paragraph 70 of her statement. She also highlights the MPS's attitudes to the use of force when dealing with public disorder, which is set out in the Police in Action report, and in particular, the untrammeled use of violence. The observations of the PSI researchers match Ms. Langford's experience of police violence towards demonstrators and strongly corroborate her evidence about that. Finally, Ms. Langford wishes to draw attention to her statement in which she answered 22 Rule 9 questions from the inquiry. In that statement, in the spirit of cooperation with which she has always approached this inquiry, she answered a series of questions in detail about her political views and family circumstances. She respectfully submits, however, that neither the intricacies of the varying political stances taken by groups or individuals whom the SDS spied on, nor her contentment with private childcare arrangements between her and her husband, are of relevance to the issues before the inquiry. As explained above and in the Category H closing, long-term intrusive undercover policing of the type carried out by the SDS must be lawful and strictly justified at the time. It was not. In those circumstances, the only relevance to the inquiry of the views of those spied on is that they were extensively observed, recorded, and shared by the police, and then stored by the security service for decades, even though it was unlawful and unjustified to do so.
Thank you very much indeed. And you had a by our standards, a lengthy afternoon, and I'm grateful to you for the cogency of your submissions. Thank you.
Thank you very much, sir. Come in.
Mr. Morris, would you like to begin your closing submission?
Thank you. I've been involved since 1974 in a range of groups and campaigns trying to encourage people to support each other and to make the world a better place. Such groups include ones promoting libertarian, socialist and anarchist politics, workplace solidarity, environmental campaigning including London Greenpeace, opposition to corporate power and exploitation, including being one of the two defendants in the McLibel case, and involvement in community groups promoting local mutual aid and self-organisation, speaking up for their needs as local residents. I am currently Secretary of the Haringey Federation of Residents Associations and Chair of the National Federation of Parks and Green Spaces. The essence of my personal motivation and political beliefs has remained constant throughout the last 50 years or so. The desire to tackle injustice, to seek improvements in society in the public interest, and to encourage and empower people to have as much control over their lives as possible. I will now read out my written statement and will make some additional comments in response to yesterday's submissions. I welcome and am guided by the general statement of 90 core participants from September the 24th, 2020, which I append to my written statement. I hope I can do justice to those collective views and further amplify some of those points made by 90 of us in this inquiry. Please see my previous opening statements for more detail, especially about my own experiences, which are appendices 2 to 4. I have incorporated or referenced a few of their key points in this statement. I welcome the closing statement of Kirsten Heaven on behalf of all the cooperating core participants, and that's due tomorrow, and our other lawyers' closing statements. They, of course, include a wealth of detail of the range of undercover operations, the unlawful and unacceptable tactics employed, and the impacts on so many groups and individuals. I also welcome the statement by the counsel to the inquiry made yesterday, paragraphs 108 and 117 of his written statement, in which he concludes that the SDS should have been disbanded in the 1970s and that things continued to go wrong despite the RIPA Regulation of Investigatory Powers Act in 2000, and that being the key issue for why things continue to go wrong despite the new regulations, and whether the current statutory framework is adequate. I also welcome the statement by the Metropolitan Police Service, paragraph 152 in their written submission yesterday, in which they say, nothing should be taken as any kind of suggestion that deployments of the type carried out by the SDS in this Tranche 1 period would be authorised today. They would not. By modern standards, the SDS's deployments in this period are unjustifiable, not least because there was a failure to consider intrusion, necessity, and proportionality. And I note the word unjustifiable being stronger than just unjustified. In this statement, I will outline 6 key themes: how the undercover policing operations became a major scandal, now recognised at every level; 2, what kind of activities, campaigns and movements I've been involved in and why. 3, how I was targeted. 4, what everyone has learned so far. 5, what remains to be uncovered, learned and achieved. And 6, some important recommendations by core participants. Credit is due to all the victims and campaigners who have spoken out, and to all core participants who've worked together for many years, supported each other and exposed the truth. This includes our coordinated campaigning through, for example, the campaign opposing police surveillance, Police Spies Out of Lives, the Blacklist Support Group, the Monitoring Group of Family Justice and Anti-Racism Campaigners, the Network for Police Monitoring, and the Undercover Research Group. We also thank the Unite Union and the 200 trades union branches who have affiliated to the campaign, and the Lush Company, who have also actively backed the campaigning. Everyone involved with this inquiry must give special credit to the women shockingly targeted by undercover police officers for sexual relationships. They were the first to investigate and eventually uncover and expose the extent of deception and depths of abuse the undercover units were prepared to employ. I strongly recommend everyone to read the book written and published last year by a group of such women called Deep Deception. It is vital and damning evidence for the inquiry. These efforts should not be underestimated. The long and often opaque inquiry has been exhausting and frustrating for CPs, and many have fallen along the way, e.g. due to age, illness, or not being properly engaged and listened to, finding the history too personal or unsavoury to engage with, or just being fed up with the time it's all taking, and so they've moved on. They have fallen away without yet getting the truth and justice they deserve. Justice delayed is justice denied, including for the millions of members and supporters of targeted organisations and movements and campaigns who are also entitled to know the full truth and to be confident that such secret political policing will never be tolerated again. The lawyers acting on our behalf have eloquently and persuasively summed up the evidence obtained and the legal implications. I'd like also to thank the investigative journalists who have published in-depth articles and books. Finally, I'd like to credit the Met Police whistleblower, Peter Francis, a former undercover officer, who helped expose the reality of what his secret unit was really up to, including the infiltration of the Stephen Lawrence Family Justice Campaign. Any UCOs or members of MI5 who wish to turn whistleblower and tell the full truth are welcome to contact me or any of the CP's lawyers in confidence anytime. It will be greatly appreciated. There have been a number of legal and official milestones which have formally recognised the depth and scale of the undercover policing scandal, slammed the SDS and called for action. These milestones include the Ellison Review in 2013 into the, quote, seriously flawed, unquote, police investigation into the murder of Stephen Lawrence. The review made a range of devastating findings against the Met Police and the shocking role of the SDS in targeting the Lawrence family campaign. Then, Theresa May's statement to Parliament on the 6th of March 2014, saying she was, quote unquote, profoundly shocked by some of the Ellison Review revelations about the Met and the SDS, and that therefore she was initiating this public inquiry and calling for, quote, a change in culture, unquote, in the police. The next important step was the Metropolitan Police's 2015 apology and payment of compensation to 7 women targeted for fraudulent sexual relationships by SDS officers. The next step was the Investigative Powers Tribunal powerful legal judgment in favour of Kate Wilson and against the Metropolitan Police's spying operations, ruling that the undercover policing units did not meet a pressing social need and were not necessary in a democratic society. The recent conclusion of this inquiry's legal team is therefore to be welcomed, that the SDS should have been disbanded in the 1970s. That's now reinforced by the Metropolitan Police Service's agreement that the deployment was unjustifiable by modern standards. The rights and laws breached by the SDS are not just ordinary lawful rights, they are specially protected rights enshrined in law and international human rights charters around privacy, the need for warrants to enter homes, right to trade union activity, rights of assembly and freedom of speech. The reason there are such laws giving additional protection to such activities is precisely because governments and other powerful interests will otherwise constantly seek to extend and abuse their powers against the public around these matters. The police therefore have a responsibility to resist government pressure to attack such fundamental rights, and a responsibility to defend those rights and not to undermine them and those who exercise them. The various groups I have been involved in, the various groups I have been involved in over the decades have been open and democratically or collectively run, and engaged in the kind of public activities which the public are invited to join in or to replicate for themselves, and which are essential if humanity is to progress and survive. All my activity which was being monitored was traditional and legitimate political and campaigning activity, albeit much of it at the radical and libertarian end of the left-right spectrum, producing magazines, exercising hard-fought-for rights to freedom of speech and assembly, attending or helping organise protests and social events, demonstrations, public meetings, picnics, attending union meetings, supporting industrial disputes, defence campaigns for people arrested, and so on. Such groups, as we all should, question and challenge those institutions which wield power over people's lives and control the world's resources, those institutions which wield power over people's lives and control the world's resources and decision-making. These include governments, transnational corporations, military organisations and financial institutions. Such powerful institutions are generally tightly controlled by a small, self-serving elite, continually obsessed with power and profit, and are ruthless and unaccountable. In fact, as I outlined in more detail in my April 2021 statement, they are subversive of society and people's real needs. They are the real subversives that need to be investigated. Indeed, they are also the inevitable cause of most of what the SDS would define as public disorder, which happens in response to unfairness and injustice. Unsurprisingly, such powerful institutions have made a shocking mess of the world for centuries, causing mass hardship and poverty, disempowerment, discrimination and oppression, exploitation of workers and resources, horrific wars, and large-scale environmental destruction. They have brought humanity to the brink of nuclear annihilation, and have been systematically exploiting and destroying the natural environment upon which human society depends for our survival. As a result, our species now faces a catastrophic and possibly terminal future. Many of the groups I have been involved with have come to the conclusion that the evidence of history demonstrates that such powerful institutions can't be successfully reformed and turned into benevolent, useful public bodies. However, history also demonstrates that grassroots movements for change, if large enough and determined enough, can shift the balance of power and win concessions and victories for the public along the way. The groups I have been involved in have tried their best to support efforts to build single issue and other campaigns and movements to improve things in the here and now. Some of those groups logically also call for the hierarchical and authoritarian institutions which are causing the shocking problems humanity unfortunately has to face to be transformed or replaced in the long term by a genuinely democratic way of running society. One in which people all over the world collectively manage their own neighbourhoods, workplaces and lives, and ensure that all the resources are shared fairly and all decision-making is for the public good. In fact, most of the groups, organisations and movements targeted by undercover units over decades share some or most of the aforementioned and wholly legitimate characteristics and beliefs, basically challenging the oppressive and unfair status quo in order to improve things for all, which is why they were targeted. I just want to respond to some of the comments yesterday in the police submissions regarding so-called extremism and public order. What is extremism? I note the characterization yesterday of, quote, extreme left wing being something to be demonized and suppressed, as if the extreme left wing comes from another planet and exists to systematically create disorder to somehow thereby ferment revolution. Protests and protest movements, in fact, are caused by significant injustice and oppression, leading to people responding to try to address and change that. Revolutionary groups exist because many people in protest movements want real and lasting change and don't think that will come through Parliament. But revolution can only happen if the majority of people want real change and make it happen themselves. The extremism, demonization is particularly used as if somehow the so-called extreme left is equivalent to the extreme right wing during so-called tit-for-tat confrontations. This was said yesterday. This false so-called equivalence between fascism and anti-fascism is shockingly disrespectful of those who have challenged very real fascist threats at certain times to the well-being of our society and to particular sections of our society. Such false equivalence is frankly nauseating. It is also lazy and inaccurate. Fascist groups are psychopathic organisations committed to spreading hatred, division, fear and terror in order to seize power and impose via mass murder a military-style dictatorship in which all opposition and civil society is wiped out. Those who actively oppose this are to be commended and supported by all publicly spirited people, not denounced as just as bad as them or extremists. So what is extreme? What is really extreme? Is capitalism, where decisions are made, as happens now, on the basis of increasing the wealth and profits of the rich and powerful, extreme. An Oxfam report last month revealed and condemned the fact that the world's extremely richest 1% increased their already obscene wealth by £21 trillion since 2020, whilst the vast majority of us are forced to undergo and protest about austerity policies, wage cuts, price rises, and cuts to public services. Is an unscientific approach to the climate emergency extreme? That is, the current ever-increasing global carbon emissions threatening humanity's future. Such extremism inevitably leads to increasing demands and protests for the immediate effective action now required. As I said in a previous statement, the most extreme challenge we all face and probably have ever faced is the climate catastrophe being caused by governments and corporations promoting unbridled resource extraction and consumerism based on fossil fuel extraction. In 1968, the American Petroleum Institute had commissioned US Stanford Institute scientists to look at the consequences of burning fossil fuels. This is at the same time as the SDS being set up. Those scientists said that continuing to burn fossil fuels would lead to increases in temperature at the Earth's surface, and that significant temperature increase could lead to melting ice caps, rising seas, and potentially serious environmental damage worldwide. They said, quote, "There seems to be no doubt that the potential damage to our environment could be severe," unquote. That was 50 years ago. So who is being extreme? The fossil fuel companies or those who are protesting and trying to create a sustainable society? Is apathy or inconsistency of efforts to make things better extreme? Or is it important, vital to come up with a long-term and coherent political vision and strategy that will actually make a real difference? Is reliance on Parliament and politicians to solve society's serious problems extreme? Or is it sensible, alternatively, to empower ourselves in our communities and workplaces to work towards people being able to take over the decision-making collectively for everyone's benefit? Are top-down authoritarian laws and practices extreme? There are ever increasingly dictatorial governmental powers over people's lives. Or is a libertarian and anti-authoritarian way of doing things based on devolving power to the grassroots more sensible? By various of those yardsticks, and although groups differ in their character, priorities and activities, most of the groups targeted by the SDS and security services are not extreme, but are instead rather sensible in challenging government policy and supporting ordinary people to campaign for their real needs. In my view, most religions and governments are, or potentially are, extremist and totalitarian unless restrained by a strong and assertive civil society. All governments support mass state violence, for example, wars and weapons of mass destruction, and police violence to impose their laws and ensure the maintenance of the capitalist status quo and its attendant injustices and oppressions. So coming along to myself and how I was targeted. I was targeted from the mid-1970s for at least 30 years, and probably much longer, for my political, social and environmental activism. As we have heard, in the 1970s, Anarchy magazine, a theoretical periodical produced by collective meetings openly advertised, was infiltrated by Graham Coates, cover name, who fraudulently befriended and latched onto me in particular. I was also involved as a post office worker, active in my union, in the London Workers' Group. It held fortnightly openly advertised meetings to discuss key issues facing workers and to encourage workplace solidarity and opposition to exploitation by employers. The group was infiltrated and the spy volunteered to become the treasurer of the group. In the next tranche of evidence in the inquiry, we will hear about how, at the end of the 1970s and the start of the 1980s, the SDS targeted the large UK-wide grassroots movement, of which it noted I was part, challenging government policy promoting the growth of nuclear power plants and the transport and dumping of dangerous radioactive waste. Not long afterwards, an accident at the Chernobyl nuclear plant in Ukraine caused an estimated 9,000 to 16,000 deaths across Europe, including in the UK. I later got involved with London Greenpeace, a small but influential environmental group who had been very active in the anti-nuclear movement. In Tranche 2, we will hear about how 3 undercover police infiltrated the group over a 10-year period. One of them, Bob Lambert, helped write the group's What's Wrong with McDonald's fact sheet, which became the subject of the longest and one of the most controversial trials in English legal history, in which myself and my colleague Helen Steele defended ourselves. Bob Lambert had a number of sexual relationships with women activists to boost his information gathering, and even fathered a child before abandoning him and his mother. He also, it was later alleged in Parliament, acted as an adjunct provocateur to get others arrested and jailed. What was the SDS's reaction to all these disgusting misdeeds? He was promoted to the head of the unit. It should be noted that after myself and Helen tracked him down and confronted him over 20 years later, he was interviewed on Channel 4 TV and had no option but to apologise for his behaviour. We will hear also in Tranche 2 how the next police spy to infiltrate London Greenpeace, John Dines, engineered a long fraudulent relationship with Helen Steele while she was preparing for the legal battle with McDonald's. His sudden disappearance, faking a mental breakdown, caused her intense stress for over 20 years. During the SDS's infiltration of the group, McDonald's also sent in infiltrators. During the McLibel trial, we were able to expose collaboration between the police and McDonald's. In 1999, we sued the Metropolitan Police, and they were forced to issue an apology and to write to all officers in London to tell them not to pass on information to third parties. I look forward to Tranche 2 and the rest of the inquiry, but for now I will mainly focus on what fundamental things we've learned so far. One, the undercover policing units were secret, wholly unjustifiable and illegal operation from the beginning and throughout their existence. Two, they were a colossal waste of time and public resources. The evidence of undercover officer Graham Coates, who targeted me, is significant. For 3 years, he targeted first the International Socialists and then anarchist groups. In his statement, he concluded, quote, "The anarchists I reported on posed a minimal challenge to public order. I do not think either the International Socialists or the anarchist movement were subversive in terms of their actions. I do not believe any info I provided was particularly significant. I do not think it would have made any difference to public order if I had not worked in the SDS." Unquote. 3. The SDS were funded, backed and praised and covered up at the highest level of government and police throughout their existence. 4. They targeted at least 1,000 groups, almost exclusively left-wing and campaigning groups and movements, which were challenging the policies and practices of the government, capitalism, and the police. These movements were, and still are, representing the hopes and wishes of millions of people. 5. The SDS deliberately targeted mainly those in those movements who were usually the most committed, most determined, most clear-sighted on how to reach the agreed goals of such movements. These principled, dedicated and generally selfless people, voluntarily in their own time, were then insultingly and wrongly categorized as so-called extremists and subversives, and somehow less than human for actively caring about and supporting people's real needs, questioning and challenging the powerful, and actively seeking a better society for all. 6. Unacceptable, disgusting and illegal tactics were systematically employed on an industrial scale for decades by the SDS and the NPOIU, e.g. The adoption and abuse of the identities of deceased children, the entry into people's homes without warrants, the invasion of people's private lives, the abuse of women as sexual targets, one victim describing what happened to her as, quote, being raped by the state, mass surveillance and hoovering up of private information to be passed on to customers for their use and abuse, including illegal blacklisting of active trade unionists and activists on a mass scale. 7. The phone hacking scandal rightly caused public outrage and calls for action, including prosecutions, jailings and closure of the News of the World. But the SDS's behaviour was 1,000 times worse than phone hacking a few messages. This was life hacking, often for years. 8. The police never considered the welfare, as well as the human and legal rights, of those members of the public they targeted. Surely any normal human being would do so. Surely as public servants and in a position of power, they had a duty of care whilst invading and influencing people's lives. After 8 years of the inquiry, many thousands of people in groups targeted, whether those groups have already been revealed or so far are still concealed, remain in the dark about who spied on them, what information was collected, and what was done with it. They are understandably angry, as well as being confused and suspicious about which individuals from their past may have been police spies, and events from their life which may have been secretly invaded and manipulated by state agents, cynically masquerading as their friends and colleagues. This delay is unacceptable, and we need the full truth. 9. In contrast, the public inquiry, at the behest of the police, is strongly applying privacy and human rights concerns to protect the identity and welfare of undercover officers. This sudden police conversion to such rights, not previously of any concern of their secret units during their operations, is surely staggering hypocrisy. It would be seen as ironic if it wasn't so serious. Many might think that those who secretly invaded and abused people's lives should have vacated their own privacy rights. Furthermore, in most core participants' opinion, the privacy strategy of the police during this inquiry is the key cause of its massive logistical problems, costs and delays. 10. The public might expect that the inquiry's determination to invoke human rights laws to protect the privacy of former undercover spies, despite their abuses of the law, might be applied 100 times more strongly when protecting the rights of those victims who were seeking a better society and who were thereby secretly targeted, lied to, abused, manipulated, and reported onto the secret services and other customers. 11. It is pretty clear that from the beginning and throughout the life of the SDS, they were dominated by the needs and obsessions of the shadowy security services, MI5, etc. Almost all undercover officer reports seem to have been sent to Box 500, i.e. the security services. 12. Fascist organisations were not targeted by the SDS despite the recognition that they were likely to be violent, their predilection for crime, and their promotion of hate speech, not to mention their organising to impose by force a fascist state on society. These were exactly the sorts of things the SDS were claiming they were supposed to exist for. 13. Why did the SDS do what they did, and how did they get away with it? Because they could. It seems that the old adage is true: power corrupts, and absolute, especially secret, power corrupts absolutely. 14. To the Met Police's current scandal over its pervasive and toxic sexism, as recognised by its current Chief Commissioner, can be added previous inquiries' findings against them of institutional racism and institutional corruption. The SDS has demonstrated that such entrenched problems in policing culture go back a long way. We believe that the undercover policing practices sanctioned at the highest levels also demonstrate a clear anti-democratic bias and culture. 15. Not only did the SDS turn their eyes away from fascist movements and their violence and subversion, they and the security services also ignored the systematic and daily mass capitalist violence against the public, its often illegitimacy and illegality, and its subversion of society. This includes daily industrial scale breaches of health and safety and workers' rights at work, landlords' illegalities and intimidation of tenants on a massive scale, the subversion of society and even of the state by the practices of particular industries and their propaganda forced on the public. For example, the fossil fuel industry, tobacco, junk food corporations, construction companies, tax havens and tax avoidance, and so on. Why weren't the SDS and the security services targeting employers and landlords organisations, corporations and financial institutions? In fact, by targeting the left, trade union activists and progressive campaigns, they were in effect actively protecting capitalist wrongdoing. 16. The campaigning causes SDS targeted are generally on the right side of history, and in many cases successfully so, countering apartheid, racism, sexism, for women's equality, for trade union rights and adequate pay, against blacklisting, to protect the environment, for animal welfare, for equal rights for lesbians and gay men, to hold the police accountable, and so on. All those are now enshrined in law and/or mainstream public opinion. Those campaigns and those who were pushing hardest for them should have been enthusiastically supported by all public bodies, including the police, not targeted and undermined. It should be recognised that history vindicates progressive campaigns and movements, despite them being attacked and undermined at the time as extremist or subversive. For example, movements against slavery, for trade union rights. Let's not forget that trade unionists were once forcibly deported to Australia in the 19th century. movements for working class people to be allowed to vote. For example, the Chartists in the 19th century, for votes for women, suffragettes in the 20th century, and 20th century movements opposing imperialism and colonization of all the now independent countries throughout Africa, Asia, and South America, and so on. What do we still have to learn? We look forward to seeing and hearing the evidence relevant to Tranche 2 and the other tranches, the documents and the hearings. This will be accompanied by the evidence provided by those we know were targeted, core participants and others. We are still calling for substantial disclosure. The undercover officers' cover names, their photos, the names of all 1,000 groups reported on, the files held on these groups and their members targeted. This is crucial so that the people, core participants and members of targeted groups and the wider public can get the information they are entitled to and the closure that they need, the full understanding of the extent and impact of the scandalous operations and an opportunity to respond. Finally, recommendations for action. In conclusion, the inquiry is called upon to support the recommendations of the People's Inquiry organised by non-state core participants in July 2018 in Conway Hall, London, as reaffirmed in the joint statement by the 90 core participants in November 2020. And I set that out in full in my appendix, but in the appendix below. In summary, what is needed is full disclosure of the names of all the spies, all the organisations they targeted or reported on, and the files on individuals and groups which were compiled by these units and related bodies. 2, a finding of institutional sexism, racism, and an anti-working class, anti-democratic agenda in the police, and a requirement to address it effectively. 3, a recommendation that undercover or secret political policing of progressive protest and campaigning groups, including by special branch and the security services, ceases, and all such existing specialist units are disbanded. Many are also calling for an apology from the government and appropriate compensation to those most affected by the targeting operations. Thank you very much.
Thank you very much indeed. You've kept well within the time that you estimated. I'm grateful to you for it. Thank you.